All right, welcome back, ladies and gentlemen, to what may be the most important day of our class. What's at stake in the cases that I'm going to talk to you about in these two short videos, that's Sherbert, Thomas, and Smith, is far greater than religious freedoms, which is what this unit is about. What's at stake, in some sense, is the very meaning of liberty itself. Now, the general abstract question that we want to ask is, how do we balance the laws that are necessary to maintain society with the freedoms that we entered into society to maintain? Answering that question involves justices, as we've already seen, in the unavoidable need to judge how important various freedoms are and how important various laws are, and to engage in sometimes complicated reasoning, and it's not always legal reasoning, in order to somehow balance these goods against each other. Now, we'll see by the end of the day today, by which I mean these two videos, that by 1990, Justice Scalia had gotten fed up with the courts weighing all these questions that might, he thought, better be put to theologians or legislators or to the people themselves. So he asserted in Oregon versus Smith that judges should stop playing this balancing game. He wanted essentially to return to the old Gobitis standard, approving of all laws that were generally applicable and didn't target any particular religion. But his Smith decision never really put this issue to bed. Indeed, especially among conservatives, there was a visceral reaction against Scalia's decision and his reasoning, and a nearly 3-decade-long quest began to return to some sort of balancing tests. And that quest essentially wanted to put judges back into the thicket of getting involved in these sticky questions again. Now, just to underline how unusual that is, there was, in many corners, but especially in conservative corners, a reaction against Scalia's conservative decision. Now, I said last week that there's a sort of philosophical problem that emerges when we try to base decisions about liberty on some sort of philosophy of human autonomy. On the upside, this notion of autonomy gives us something. It gives us some sense of why we grant liberties in the first place, so that people can make their own decisions. But it has a twist to it, because it also means that any restrictions have to have been accepted by people themselves. People are, and they must remain on this view, autonomous, restricting themselves via some higher order will that they have. And the question is then, when can judges say that the people themselves have actually accepted the laws they have chosen through their legislature and accepted that these will override their other choices, even if those other choices are based on some seemingly important religious values? When have people accepted that the law overrides those? And this can be a real problem. I'm going to go over some of our religious freedom cases to show you that problem. With Yoder and Mozart, our cases from last week, we saw state policies that assumed it was okay to restrict people, to force them to go to school, in order to encourage critical thinking, to enhance their own freedom of choice, i.e. autonomy. But the Amish and the fundamentalists in those cases rejected the idea that individual choice is the only way to come to have your own values, to be autonomous. They said they have their own ways of coming to have values, and they would never accept principles that would force them to stop their own ways of life. So these cases opened up a question for us. If it's important that each person accept the restrictions on them, does that mean that everyone can get exemptions? And should we even care if people's reasons are religious in nature? In our conscientious objector videos, we saw that the court says that making religion the only area of values that is held sacrosanct from state intrusion actually violated the freedoms of those like Mr. Welsh, who took other non-religious things to be important to them. If the important part of freedom is that people be able to follow their own highest commands of conscience, be able, in other words, to direct themselves by their own autonomous higher order wills, we might say, then we can't really say that we'll only care about the commands of conscience if those commands are religious in nature. And if we grant that, all of that, combining all of that together with what we saw was a problem in the Yoder and Mozart cases, does it mean that everyone can claim exemption from state laws whenever they want to, based on whatever reason they want? You saw why Scalia got concerned about this. Now, let's see how the Supreme Court actually struggled with these dilemmas from the Sherbert case in the 60s to the Smith case in 90. We'll look in particular at the role of democratic legislation in that autonomy calculus today. The Sherbert decision placed a lot of restrictions on when a democratic body could place legitimate laws restricting the people themselves. But Justice Scalia, in the Smith decision, said that all of the problems inherent in this autonomy approach were just too much to handle, just too messy for judges to wade into, so he decided he would simply rely a lot more on democratic legislatures as the real arena for debating these questions of liberty. And I want to remind you again of the Gobaitis case, right? I'll show you a couple of ways in our second video that Scalia was inspired by the Gobaitis case in some of his reasoning in the Smith case. Okay, so let's start with Sherbert versus Verner, an incredibly important Supreme Court case from 1963. And we're going to go in our usual order this time, so we're starting with the facts. Adele Sherbert worked at a textile mill in South Carolina, but she'd been fired from her job. The mill had switched during the time that she worked there from a 5-day-per-week schedule to a 6-day-per-week schedule, and Mrs. Sherbert, who was a member of the Seventh-day Adventist faith, refused to work on Saturdays, which were her Sabbath days. Mrs. Sherbert applied for unemployment compensation from the state, but she was denied because the state said it was her own refusal to work on Saturdays that had actually caused her dismissal, and then her inability to find suitable work after she left the mill, say at other mills that used the same 6-day schedule. So here's the legal issue that the court had to encounter. Mrs. Sherbert said that the state action of denying unemployment compensation to her created an unmistakable pressure on her to break with her exercise of her religion. To get her benefits, she would have to be willing to work on Saturdays, then breaking the command of conscience that came to her from her religion. Members of more common Christian denominations, which worship on Sundays, wouldn't be forced to make a choice like this because there was actually a provision in state law that said Sundays was out of bounds. And because of this, she argued that the law was a burden on her free exercise of religion. I want to point out here that she did not argue that the law established those other mainstream denominations as the state religions, but she was saying that this law was specifically a burden on her exercise of religion. So she was asking for an exemption here, not the invalidation and vacation of the entire law. She just wasn't saying that it established mainstream Christianity. She was simply saying that without an exemption for her, she couldn't exercise her Seventh-day Adventist creed. But the question then is, was it constitutional for the state to burden her religion in this way? Simply saying that she was burdened is not enough. The court had to ask if the burden was justifiable in some sense. So Justice Brennan articulated a rule in the Sherbert case that came to be known as the compelling state interest, least restrictive means test. It required two things. One, that for any law with the sort of effects on religion that had been placed on Mrs. Sherbert to be constitutional, it had to pursue some very strong state purpose, compelling. A state could not, for instance, restrict religious exercise merely so that it would be easier to clean the streets, just to give an example. Second thing it did was that even if the state had a compelling interest, the law had to carry out that interest in the way that was least restrictive of religious exercise. So the state couldn't pursue even a strong interest in, let's say, health and safety by banning the kosher slaughter of animals if, for instance, just regulating the place and the manner of kosher slaughter would do to accomplish that state interest. Now, the compelling state interest least restrictive means test is what we have called a balancing test. It's only one of a number of possibilities, but it may be the most important one in Supreme Court history. It seeks principles that draw a line between an area in which a state can regulate and one in which a state cannot regulate, and it does so by balancing the strength of a state's interest in a regulation against the strength of a person's claim to be free, to be left alone in some area that is important to them. Now, this is crucial. This test requires a court to look into a person's claim to have some important value, and sometimes to hold that their claim of conscience is higher than state laws, but sometimes to hold that it is not higher than state laws. Brennan tries to deny up and down in the case that there's any need to examine individual beliefs. We saw that pretense explode later in the Seeger and Welsh cases about the Vietnam draft. We saw the court there say, yeah, you know what, to tell you the truth, we got to examine things about the person's religious claim. Brennan in Sherbert tries to say that they're really only on the side of judging whether the democratically chosen law is valid, but we'll see that it's hard to make the judgments in this case without making some sort of judgments about individuals' freedoms, some sort of judgments about Mrs. Sherbert's freedom claim. So take a look here at what I'm going to show you on this quote in front of you. The crux of the case, Brennan says at 406, is that the court must consider whether some compelling state interest enforced in the eligibility provisions of the South Carolina statute on unemployment compensation justifies the substantial infringement of appellant's First Amendment rights. It is basic that no showing merely of a rational relationship to some colorable state interest would suffice. In this highly sensitive constitutional area, only the greatest abuses endangering paramount interests give occasion for permissible limitation. Okay, so this quote is chock full, and I'm gonna unpack it for you sort of word by word, concept by concept here to show you how some of the things I was already saying about the Sherbert case are contained in, argued in this really, really important rule that they articulated. Okay, so the first thing we have to notice is that there's sort of a pretest to the compelling state interest least restrictive means test, and that's the substantial infringement prong, also known as the substantial burden prong. To justify protection under the First Amendment, Mrs. Sherbert's claim has to be religious in some way, the court is saying in this quote, and she has to show that there's some sort of pressure to conform that's being placed on her. A sort of pressure to conform of the sort that I just talked to you about, that she's being forced to choose between state benefits that are open to all and the exercise of her religion, something like that. So that is, she has to show a substantial infringement or a substantial burden on her religion. But the court asks more than just whether the person has a belief that meets some definition of religion. They also get into the type of analysis that we saw later in Seeger and Welsh. They ask about the quality that the belief has for the person. Specifically, they ask about sincerity and centrality. There's a little noticed footnote on page 399 where Brennan says this: "No question has been raised in this case concerning the sincerity of the appellant's religious beliefs, nor is there any doubt that the prohibition against Sunday labor is a basic tenet of the Seventh-day Adventist Creed based upon that religion's interpretation of the Holy Bible." So you see, they're basing their argument in part here on Mrs. Sherbert's sincerity and whether the claim she's making is based on a basic tenet of her religion. Now, they're saying no question has been raised in this case, so in other words, we don't need to consider that in this case, but the implication there is that it could be important, it would be important in other cases. So, that's all the substantial burden or substantial infringement prong, and if a substantial burden on a religious belief is found, meaning that the burden is religious in nature and it touches a sincere and central belief, then the court is stepping into what Brennan called a highly sensitive constitutional area. So let me go back to the same quote that I was showing you earlier here. Here Brennan is invoking something that the Supreme Court calls its doctrine of strict scrutiny. And with such a sensitive topic, he's saying, no showing merely of a rational relationship to some colorable state interest would suffice. We saw that was a basic balancing test that had been hinted at in Meyer, elaborated in Pierce, but Brennan is modifying it. He wants more. He wants the test to be much more protective of freedom. Instead of a colorable interest, Brennan will require a compelling interest. Okay, so what will this test mean in the Sherbert case? Well, the state interest that South Carolina invokes in this case is that they can't hand out benefits to just anyone who claims to have a religious principle against working on some day. They'd become bankrupt. The state says that this would encourage malingering and false benefit claims. It would cost the state a ton of money. But Brennan says, basically, look, sorry, you haven't shown any proof that you'll lose all that money, and at any rate, you've got claims review boards in place that can suss out which of them are the sincere claimants and which of them are the liars. So he says your interest, although it's valid, isn't compelling, really. So in this highly sensitive constitutional area, Brennan says, you have to tread more lightly. He says on page 407, take a look at it in front of you, even if the possibility of spurious claims did threaten to dilute the state's funds and disrupt the scheduling of work, it would plainly be incumbent upon the state to demonstrate that no alternative forms of regulation would combat such abuses without infringing First Amendment rights. No alternative forms of regulation, or in other words, they've got to consider all those alternative forms and choose the least restrictive means for accomplishing their state purpose. Now, it's important to notice that in order to work out some principles for legitimate restrictions to apply in this case, the court has to ask whether the person could, in some theoretical sense, see the commands of the state as being higher than the commands of their conscience. Now, the court isn't saying that each person has to personally accept the restrictions placed on them, but ask yourself, what else could compelling mean? Compelling to whom? It's not to the state. South Carolina had already said it had reasons for its law, but the court rejected those reasons. It must be compelling to the very person who's being restricted. The court is suggesting that it's possible for some state body, themselves, an unemployment review board, a draft board, and other cases we looked at, to look in and know from the outside whether a person's command of conscience is in fact higher than the state law. In other words, they're looking into that very person's reasoning, whether they would consider their high command of conscience to be more important than the state law, or whether the state law could compel even them. They're not saying that it's up to the individual to decide what state commands to obey, at least not implying that yet, but they're at least saying in Sherbert that the person will have to accept in some cases that the commands of the state are higher despite their beliefs. So this is important because after the Sherbert case, the court decides Seeger and Welsh, which you already learned about, and it expands its protections of conscience even to claims that are not religious in nature and may be merely personal and not fully comprehensible to anyone else other than the claimant. Again, hinting there that it's not actually the court's reasoning, it's not the court saying this law is compelling to us, right? because they're saying, we looked at Mr. Welsh's claims, and those claims might be incomprehensible to us, but they are, to him, higher commands of conscience, higher than the state law, even a compelling state law. It says basically only that to override the commands of the state, the person's conscience has to be sincere and meaningful to them. We saw those quotes. So that's why I had you look at the Thomas case. It's sort of an interim case between Sherbert and Smith, and it actually applies the reasoning of Seeger and Welsh to a familiar type of case, a case very much like Sherbert. So here's the facts. Mr. Thomas was a steel factory worker and a Jehovah's Witness who objected to a transfer that he'd received at his job because in his new position, he'd be making steel that went into tank turrets. He said that his religion made him opposed to contributing to war efforts, but he was conflicted in his own beliefs about this, and he admitted maybe even a little bit confused and unable to convey his beliefs clearly to others. And it was the case also that other Jehovah's Witnesses in his congregation and at his factory, who were Thomas's friends, themselves said they had no problem working to produce tank turrets and did work to produce tank turrets. Thomas quit the job that he'd been transferred into, applied to the state for unemployment compensation, was denied by the state of Indiana because his beliefs were confused and not shared by any organized faith. But, and you remember that's the same thing that was going on in Welsh, so you'll see what's coming here, but the Supreme Court determined that the state required a compelling interest to override Mr. Thomas's conscience and that they didn't have it. The reason the court took this case was in fact its similarity to Sherbert. They were both about unemployment compensation, and they both involved changes in someone's work situation that caused them to have new religious doubts about their work situation. So they took this case in order to establish a new precedent or to expand the Sherbert precedent. They allowed Mr. Thomas to make a claim of conscience, not religion per se, that they deemed to be for him higher than state laws. So we're going to take a look at our next video at how Scalia reacts against really an entire 30-plus year trend of establishing this sort of argument in Supreme Court precedents for what they call strict scrutiny, what's called substantive due process, or in the specific case of Sherbert, the very well-known, very famous compelling state interest, least restrictive means test. So we'll see Scalia's reaction to that, and then we'll discuss a case in class which tests or probes your acceptance of these tests. All right? I look forward to seeing you in the next video and in class.